and I wish we were in the other body with 7 to 10 minutes for each of us. I know, Mr. Chairman, that is not the case. Let me welcome the Assistant Attorney General and thank her for her leadership and her expertise. In the midst, Attorney General, of the fights around critical race theory, the new census that for the first time would not have the protection of the 1965 Voting Rights Act and the increasing diversity in this country, and people making this a race question, I believe that this is more crucial than ever before. And when I say that, opponents making the question of the voting rights about race. It is not about race. It is about voting rights. It is not about Black people only or Hispanic only. It is about voting rights. And I'm saddened by my dear colleagues who have made this a race question. I rebuke that. And the reason why I do, I'd ask unanimous consent to put into the record 1965, 1970, 1975, 1982, 1982 again in 2006 of the record that shows that every vote on the reauthorization and the Authorization of Voting Rights Act was bipartisan in huge numbers, Republicans and Democrats, whites and Blacks, Hispanics, African Americans, and other diverse persons in the United States Congress. I ask unanimous consent. I ask unanimous consent.
In the spirit of Jim Sensenbrenner, it will be without objection done.
And with unanimous consent, I wish to put into the record warrants served to Texas Democrats, my colleagues, brave colleagues who are fighting against voter suppression, and an analysis. It's harder to vote in Texas than any other state. We are 49th. It's harder than 49 other states, as evidenced by research in academic institutions. I ask unanimous consent for that as well, Mr. Chairman.
Without objection, it shall be entered into the record.
Madam Attorney General, I'll give you two questions that I know that you'll realize my time. The Shelby County case impaired the ability of the DOJ to appoint federal observers, having relegated us to using local observers. Would you indicate how important that question of federal observers, but how that impairs you and whether that assessment is correct so that federal observers should be reinstored, number one. Number two, under the Brnovich case, tragically undermined Section 2. We seem to have the ability to put in a bifurcated test under Section 2, one that would deal with assessing voter dilution like the redistricting, and one that would deal with voter denial claim, such as voter ID. Would you then answer how important that perspective would be? My last point would be, and I'm down to 1.50 almost, is the importance of prospective federal hearings, field hearings that could ultimately be put into the record as we move forward, both in this body and the other body. Thank you to Attorney General, observers, Section 2, and the hearings. Thank you so very much.
Thank you, Congresswoman. So on the first point, the Federal Observer Program has been an important tool in the Justice Department's work to ensure that all eligible voters, especially voters of color, are able to access the ballot free from discrimination. The Justice Department had routinely received reports about voter intimidation efforts or other tactics aimed at making it harder for voters of color to vote. And the deployment of federal observers by way of the Office of Personnel Management allowed the department to put independent eyes and ears on the ground in those communities. Those are people who could document and tabulate what was happening. Those are people whose mere presence often helped to neutralize situations that otherwise may have unfolded on the ground. And so we're very hopeful that this process will help to restore the ability of DOJ to deploy observers, federal observers going forward.
Section 2 question, yes.
With respect to Section 2, as Congress well knows, it has broad enforcement authority under the Reconstruction Amendments, but there is also broad powers vested in this body by way of the Elections Clause, which gives this body the ability to ensure access in federal elections, to institute legislation concerning the time, place, and manner by which voters are able to access federal elections. And so we urge Congress to lean on and use its broad enforcement powers to ensure access to the ballot box.
Field hearings.
And field hearings, I think, Congresswoman, are another way to further complement the work that you're doing right now. Bringing members together to kind of debate what is the appropriate remedy to address the problem is key. But particularly given the pandemic, getting on the ground and giving voters on the ground the opportunity to present to you the story about what they're seeing and what they're experiencing when it comes to voting discrimination could be an important way to further complement the record that you're developing.